So Felix Uzoma is doing this alongside me this morning. And of course, we're discussing next as we review the presidential election petition court judgment delivered yesterday. Yesterday, the Presidential Election Petition Tribunal validated the election of Bola Tinubu as the president of Nigeria, satisfied that he was duly elected by a majority of the lawful votes and that the petitions against him lacked merit and were liable to be dismissed. The court further held that the candidate of the People's Democratic Party, Atiku Abubakar, and his Labour Party counterpart, Peter Obi, failed to prove allegations of substantial non-compliance, amongst others, against Tinubu during the February 25 presidential election. The ruling, which lasted over 12 hours and delivered by Justice Aruna Samani, however, addressed 5 fundamental issues in the various petitions which have become the takeaways from the ruling. And they include that the Federal Capital Territory of Abuja has effectively become Nigeria's 37th state and did not require the hitherto constitutional 25% vote in a presidential run. That INEC was not under any compulsion to use beavers, that the electronic transmission of results was equally at the discretion of the Electoral Commission. That's 3. Well, to 4, that Tinubu's $460,000 forfeiture was not criminal and in any way was not criminal in any way. And lastly, which is the 5th one, that the candidacy of the president was fit and proper. Well, according to the tribunal, which cleared the air on the controversial 25% of votes agreeable to winner in Abuja, the Federal Capital Territory said it was not a requirement for the declaration of results, adding also that the Independent National Electoral Commission was not under any legal compulsion to transmit results electronically. Well, to discuss this or review this judgment is a legal practitioner and partner at TSEDAQAH, Attorneys Fernandez, MARCUS-OBIENE. Good morning to you, Fernandez, and welcome to the Discourse on the Law Firm Morning Show.
Good morning. It's a pleasure to be here this morning.
Yes, you're welcome, Fernandez.
Thank you, Felix.
Great. Of course, it sure would be a pleasure to discuss this with you as well today. Well, because I did bring our first guest on the show today. That's on the newsstand, this segment, by the way. How do you feel the day after the judgment?
I don't know. I feel the same way the day before the judgment. Not different.
Okay, what was your feeling the day before the judgment?
Oh, well, the truth is I didn't expect the petition to succeed, either of the petitions to succeed, personally, because I mean, in the system that we have now, current system, it's difficult for a petitioner in a presidential election petition to win. This time, the petitioners were a bit more innovative. And hello?
What's together? What are you hearing?
No, I said the petitions I saw, because I read both in advance. The petitions are a bit more, I'll use the word innovative, and our laws do not. Our current laws and the current judicial system is not one that allows so much innovation and creativity. I mean, the law is on paper, is stated. So, yes, as much as you want to try, you have to follow those set down rules and procedures. And I thought that there was some hope, but it was unlikely anyway. If there was it was going to do anything, it would be on appeal.
Okay. All right, maybe we'll get to that part. I'm tempted to pop a question right now, and maybe it's just a fine time before I forget this question, right? Well, you say if there's going to be any hope whatsoever, it's going to be when the appeal. What do you see there?
Okay, so there is usually a lot of work at the tribunal stage. So you have them looking through several documents, and it's easy for them to make. I mean, they would ordinarily, again, as a court of first instance, you want to do everything according to the books. You don't want to change anything. You don't want to offset anything. So it's unlikely that you would do anything radical at that stage. But the Supreme Court is the final court. It's not just a court of law. It's a court of policy. So if anything can be done, like I said, especially if the court intends to, because there are certain provisions of the Electoral Act and certain practices that may need to change for a petition to win. For a trial court to reach that decision on its own might be difficult, but the Supreme Court may be, because it's the final court and it's also a policy court.
Alrighty then. So let's talk about these judgments. Was put forward yesterday. It appeared, going usually what we've seen in the past with election petitions will be, 4-1, 3-2, and the rest. But apparently, it's just completely unanimous, right? Which maybe tells a lot about the pleadings of the petitioner. You know what they say, that winning a case depends on the pleadings of the petitioners. You just mentioned something in that regard. Do you think that the petitioners did enough to prove their cases?
Okay, so this popular thing that they are saying now, you say you go explain tire, no evidence. No evidence.
Someone's probably listening right now and saying you are a Gen Z legal practitioner.
Well, I'm not, but that's the thing that's going on. But in reality, in law practice, even when you have evidence, you have to explain tire. And in addition to that, you have to also bring the evidence in a way that it can be accepted. So you have evidence first, you have to bring it in the proper way, and then you have to still explain. I'm trying to say it in the layman's terms.
Yeah.
So what the court did yesterday, and what they said, in looking at the evidence, they said that certain evidence did not come in time or in the proper manner. So even if the court were to consider it, the court couldn't consider it as such, it could not rely on that. So on the basis of that, of course, that's what the court relied on to dismiss the petitions. The petitioners, I think they did a lot of work. But what we've seen is a departure from the previous system. And I thought this was an improvement from the previous petitions, because when you usually have election petitions, you call thousands of witnesses, hundreds of witnesses, prepare documents, and you have only 21 days from the date of the announcement of the results to this, and it's difficult to put this together. So, we thought that the new electoral act and the electoral system allowed for a bit of innovation, where rather than, especially with the Vivas and the electronic system, so you're able to collate. So you don't need to call everybody at each individual stage to bring evidence. You could just put that together, see if there's electronic evidence that you could use, and then one person or a few people who are experts can actually talk to those issues and deal with them. Unfortunately, that was a gamble, because as you know, in the the matter, the Osun State matter, the Osun State petition, the court actually. Yes, you see that the court sort of hinted us really that you needed to bring the actual evidence, go down to the streets and go down to the polling units, pick up that evidence. And but I think at the time it was a bit too late, because petitions had been filed, everything needed to do had been done. So yes, so I don't think they did badly. I think they did what was practical and what was reasonable at the time. The only problem is that sometimes what is practical and reasonable may not necessarily be what is adjudged to be proper, and that's what we found.
All right, Ferdinand, Kingsley, had come up with the introduction, but let's even now look at the judgment bit by bit. Let's break it down so that those out there can really understand why the Court of Appeal, or that's the Presidential Election Petition Court, ruled the way they actually ruled in the different issues that the parties or the petitioners brought before the court. There are about at least four major areas. Number one, the issue of 25% vote from the FCT. They also brought the petition on certification, that's educational academic qualification of the second respondent, who is president now, that has been affirmed by the PEPC. They also had the issue of criminal forfeiture, of the second respondent, who is that's Bola Tinubu. as well as double nomination of the current vice president. These were some of the issues. There are other issues, the issues relating to beavers. We are going to dissect these issues, and we want you to dissect these issues, so perhaps to look at them bit by bit. So maybe we'll start off from the issue of the beavers. Some people have felt like the beavers is like an innovation that has been brought, to and beavers and IREV, or the electronic transmission of the results. But the court is saying, or if I'm wrong, perhaps you correct me, but the court is saying that collation is local, is done at the polling unit. The collation of results is done at the polling unit. So the parties, that's the petitioners, ought to have brought the representatives, that's their candidate, their agents at the polling unit as witnesses. Do you not think that this would have been very difficult, or perhaps destroy the purpose of the beavers and the IREV?
Okay, so I think it will become cumbersome. Election petition is, if you've done the election petition matter, realize that it's one of the most stressful matters you can do as a lawyer. And yes, bringing in the number of witnesses that would have required to prove 175,000 polling units would have been difficult, and it's even a lot more hectic. So yes, the beavers help.
174,000. Yeah.
Yes. So doing that, imagine bringing 175 witnesses to tender these documents might be a problem. So obviously, the beavers IREV was meant to help in a way. But there's things, I think we need to clarify. There's one thing about collation, and there's another thing about monitoring, or being able to people to be able to see, which is what the IREV portal does. The IREV portal ordinarily ought to allow people to be able to monitor individuals, all of us in the house, to be able to monitor the elections as they go. But the law, that is the Electoral Act as I see it, did not require that must be used for collation of results.
But so, Ferdinand, yes. But the INEC, that's the Independent National Electoral Commission, has a manual for collation of these results, and the manual states that they are to transmit this, results in real time. So are you saying now that since it is not in the law, that's the Electoral Act 2020, we can dispense, or we can do away with the manual? Okay, so
no, that's not what it says. Now, for me, this was a 50-50 chance for that argument. It was a 50-50, and in an election petition, I think it favors the electoral umpire more. Anyway, so if they had made a decision, it's difficult to overturn unless you find reasonable ground to. Now, the Electoral Act allows the INEC to decide the mode of transmission of results, and the INEC, pursuant to that order, decided to create a manual that allows people to do certain things. Now, again, INEC was the one that prepared that manual. I have the authority to prepare that manual, and I decided that, okay, that one, because of the exigencies, because of so and so results, it cannot work. So, but this process has to go on. So, therefore, I authorize the manual transmission. Again, of course, it could go the other way, and then it could argue that, which is what I would have favored anyway, that since you are told us that you are going to do this, you are under some sort of contract to us to do this, and if you fail to do it, you should find a way to get stuff done, as opposed to you now going, because again it creates an opportunity for people to claim, for people to cry that there was foul somewhere, and because certain things were happening, you did certain things in particular way. So for me, I think it's a two-way thing. The law authorizes INEC to decide, and INEC decided in one way or the other. And along the line, perhaps as a result of some difficulty, or for any other reason, they decided, okay, we can't do this, so let's revert back to manual collation. So yes, for me, I think the argument is 50-50. I favor the argument that since they had indicated that was what they were going to use, and that was in the written law, then they ought to at least have provided another sort of written manual that allowed for this other one. In the absence of that, ideally, that should be thrown away. But again, these things are 50-50.
Yeah, Fernandez, I'm going to speak like the Nigerian who is on X, for example, or on the street of Lagos, Nigeria, on Maiduguri, on Calabar, Port Harcourt, or maybe somewhere in Benin City, listening to you and thinking, okay, does this not mean that, and you certainly addressed that, but I'm just going to expand that a little bit. If this would work, if this logic would work in election matters, because the relationship between Nigeria, or Nigerians rather, and the Electoral Commission going into the election was some sort of contract, right? And then in the middle of the execution of this deal that we have to go to the polls, there's a breach of contract, right? What happens when there's a breach of contract? It means that the person who did not fulfill his part is guilty, yes?
Okay. So in electoral jurisprudence is different. There's what we call substantial compliance.
Okay.
So you don't necessarily have to have complied with every single word. As it says, it's substantial. You have done enough to cover. Because this is a practical thing. So let me give, between those of you have a contract that I should deliver goods. I should send you an email to your particular address, and I'm not able to send you an email. And then, of course, I take that document physically, I take it to your office, and drop it to the appropriate officer in that office. I would have done my best to fulfill that obligation. I've taken steps to remedy the situation that was bad. So there are arguments as to what there were issues as to because of the amount of data that was being used on the portal. Again, that that update or upload was so that we could monitor the process, because there's a difference between the DIVAS and the IREF. The IREF portal is essentially for us as to be able to see, monitor real time how these things are happening, as opposed to the DIVAS, which was the accreditation system. Again, the accreditation system was used. You have to be accredited before you're allowed to vote, and that worked. For this other one, they could not get it done, and so they had to revise. That's what is officially said, and unfortunately for us, there's a presumption of regularity in favor of INEC. Anyway, so unless you can show, this is a problem really for the electoral system, in my view, because I think to some extent, INEC needs to also show that it did what it did properly, as opposed to just presuming that it did, because INEC could just latch on that and refuse to give you documents, slow down certain things and all that, so that you will not have the document. You have only 21 days to put your case together. And then if INEC is delaying and foot dragging, it's unlikely, which is what we've seen, because a lot of the evidence that could have been used for the petition came out after, which is why, of course, I think certain persons, which brings me to one of the more critical issues that I want to talk about. And I don't know, I hope you don't mind, but I wanted to take you away to the issues of the subpoena and the requirement for witness statement or note for those that.
Yes, just as you go there, right? I think it's necessary to note that this is exactly what the tribunal said as regards this, just to buttress the point you've made, I'm quoting directly now, that the petitioner made the allegation of non-compliance a substantial part of their case. By the provisions of section 1352 of the Electoral Act, they are required to show how such non-compliance substantially affected them. If they fail to show same, the petition fails. End of quote. So let's go to the subpoena part.
Okay, so that's subpoena part, and I'm going there. So which may have, and then before I just come directly to the subpoena, which may have informed the decision of to subpoena certain people to bring their evidence afterwards. Because again, it's difficult to get certain of this information from INEC or from third parties within 21 days. Now over to the subpoena issue. That is one of the biggest, in fact, that is my biggest issue with the decision, and I hope that the Supreme Court overturns that part of the decision. As a person, for you to subpoena a person, it means that the person ordinarily did not want to give evidence. You may have known the person, you may have had a relationship with the person, but the person does not want to come and give evidence. So because of that, you go to the courts. And then the court now decides that, okay, I agree with you. I will now order that person to come and give evidence, whether oral or written evidence. And so for the court to now require that you file a witness statement on oath for that person at the time you are filing the petition. It's unreasonable. Before now, there's a judgment of the Court of Appeal in an election petition matter in 2019 that clearly states, Amakri versus INEC, you can look it up. It clearly states that it's on. Yes, while the Evidence Act envisages that you provide a witness statement for every person that you are going to use as a witness, there are certain people that you cannot. These are people that are not available and unwilling, and it will be unreasonable for the court to insist that they should prefer somebody that doesn't want to give evidence. How do you expect him to prepare a witness statement on those and sign?
Sorry, Ferdinand, perhaps you might want to break down what you mean by witness statement on oath, so that can be clearer
Okay.
to us.
Okay.
What is
So
the witness
generally,
statement?
so generally in civil proceedings, I mean proceedings between two people that is not a crime, not something that does not relate to a crime. The law requires that when you come to court, I mean the rules of court require that when you come to court, you don't just come and start talking from A to Z. Before you come to say anything, you would have written all of that in a document, and then that document must be, do an affidavit. Essentially, it's an affidavit stating the case, your evidence that you're going to give, and you file that before the court. You sign that and file it before the court. So when you come to court, you don't start giving all the evidence, saying everything one-on-one. You just tell the court, this is the document I prepared, this is my evidence, and I want this court to rely on it.
So Ferdinand, if I get what you're saying that the witness statement is a testimony of that witness. That's what the person is coming to court to say. It will be compressed in a document. In a document form, which would now be presented or tendered in court as the person's testimony. Right.
Exactly.
So I'm really sorry. What's the wisdom in this though? If I'm going to have to present that, wouldn't that? I'm sorry. Like, how does this help my case?
Okay, so litigation is not supposed to be a game that you're hide and seek. The idea is that you have brought everything on board. Everybody has an opportunity to see so that they can review, ask questions in advance, etc. So if you have evidence or a document or something that you want to give before the court will ideally want you to bring it so everybody can see it. And if another person has a question, it goes along with the right to adequate time to prepare for defense or right to fair hearing. So the person has seen what your case is able to say, okay, this is the allegation made against me. How do I respond? Is this correct? If I'm going to ask questions, I should be able to ask questions under cross-examination on this issue. If you come to court on the day that the decision is being, that the argument is being made or that the evidence is being given and you hear certain things, you may not have enough time. It may mean that you have to seek civil adjournment for the purpose of dealing with only one person's evidence. Now, in addition, it also saves time for the courts and for the parties, because again, if I come and the court usually in Nigeria, a lot of the courts still write, majority of the courts still write longhand. We write down, the judge is writing down what you're saying as you're saying it. If the court stays and listens and writes down, you find out you can spend 3-4 hours, 5 hours just on one witness. Whereas this other way, you just simply come and you adopt your statement and then you tender the document. So that can reduce what should ordinarily be 4-5 hours to maybe 10-20 minutes. And then you're done, and then they can move on to the cross-examination of the other party.
Right. So back to what you were saying before. You're saying that the PEPC rule that the petitioner should have, the subpoenaed witnesses should have, the petitioner should have prepared their witness statements on oath before, coming to court. So you can pick up from there if you
yes. I think it's a problem. I think it's unjust in the real sense of the word. I don't know where. I mean, again, I need to look at the judgment again. Even though I listen to it, it's better when you have listened and you have read the document, so you understand it better. But it's a bit of a problem for me to grasp, because again, this is a witness that doesn't want to come, and then you're saying that before I even file my case, I have to call him to come and sign a document. And then because I did not call him to sign the document, then he cannot give evidence. For me, that's a strange. Before now, like I had said, the cases are there that this person did not file witness statement or not, because it's unreasonable to demand that they prepare witness statement or not. They come and they give the evidence as the deem fits, and then they go. So that to say that they should prepare in advance, I mean, that for me, that was the point that I have an issue with, and again, because of the way election petitions are, they say they are still generic. But the reality is that even in normal civil proceedings, people will now rely on this. So you have a witness who does not want to give evidence, and then you issue a subpoena. The court issues a subpoena because, again, this is another aspect of it. So if the court felt that person should have been your witness at the issue, the court should not have issued the subpoena. So if the court has issued the subpoena, the court has said, I agree that this person, you cannot reach this person, and there's no way for this person to have given evidence beforehand. As such, I hereby order that the person should come and give evidence orally. So for the court to turn around, in my view, and say that this person should have filed the document, for me, it's the court sitting on appeal in his own decision, which is not allowed to. But that's my personal view.
Yeah, Fernandez. Fernandez MARCUS-OBIENE is a legal practitioner, partner at TSEDAQAH attorneys. He's talking to us about the judgment we saw, listened to, watched, if you did, of the presidential election petition court yesterday. And Fernandez, we'll talk some more about this. Let's bring Lagos, Nigeria, into the conversation. They're the most affected by this. Well, you for once have said you feel the same way you felt the day before the judgment. Well, there are those who don't feel the same way. I'd like to hear from them. It's the Take the Mic segment on the Law FM Morning Show. Time to hear from you.
Take the mic. We want to hear you. On the Law FM Morning Show.
We really would like to hear from you. We really would like to hear from you. We really do want to hear from you. So, hey, 0909-555-1039 and 0703-2277-338 numbers to call. That's 0703-2277-338 or 0909-555-1039. Keep them calls coming in. Do not hesitate to share your thoughts. Just make sure that you're mindful of your language. We're here for that. Hello, good morning to you. Hello, good morning. Hello, good morning. Okay, do well to call back. Phone lines buzzing right now. Hello, good morning. Hi, good morning. How you doing? Hold on for me one sec. Pardon me. Okay, so let's see. There you go. We can hear you now. Talk to me.
Yeah, sometimes when listeners ask questions, some analysts, for whatever reason, they will try to run around the question and answer it the way it suits them. When I talk about the implication of the ruling of the tribunal as to regards to IREV now, that it was a confidence booster. But now they have also dashed confidence. To me, it seems like a campaign police by ANET this time around. They move voters. Now that they have said it as the discretion of INEC, what will be the future of Nigeria's election, especially in next general election? What other tactics are they going to use? Because if it is difficult for our vote to count despite all these things, how much more when you say it is not, you are asking me based on that you cannot compare with someone writing exam after failing. That person writing exam, his destiny is in his hand. This time around, they are telling us that our destiny is in hand of INEC, not in our hand.
Emmanuel would respond. Yeah, would respond to that. It's one of our questions to Fernandez today, definitely. But thank you so much for your contribution. Hello there. Good morning to you.
Good morning to you, Law FM. I want to thank you for your efforts yesterday to monitor the judgment from A to Z. I appreciate it because I monitor it with you as well. It's very, very clear.
Thank you too.
Well, concerning the judgment, the landmark judgment, because the judges did their own work and they made sure that all loopholes were explored. Because when you talk about all the submission of various
petitioners,
lawyers, you look at the submission of various lawyers, you find out that they are even antagonizing their ATS, like Barrister Uche, SAS, who wrote a book and was also submitting another thing contrary to what he submitted, what he wrote in the book. And the judges pointed it out to him. You see, the politics of Nigeria, it has come to a time that we have to be wise in going when we want to go to electioneering process. If you look at what Tinubu scored, 36% of the vote cast, 29% point something of the total vote cast by Atiku and 25% by Obi. And both of them were in the same party. Obi obtained the form of PDP 40 million and now jumped into a Labour Party. Now, if you add the two, you see that they have remained in the same party. They will have taken Tinubu hands down.
We can't be sure.
We can't be sure of that.
We can't be too sure. Yeah.
There are lacunas in our constitution. Look at the forfeiture issue of the money laundering, and also the lacuna in the constitution in the section 145 that says if it past 10 years, it's no more relevant. All these things are there, and they pointed it out to them.
All right. Thank you so much for your contribution.
What I want to say is that Nigeria needs to be wise. If you see a government that is not doing well, mobilize yourself together to push that government out of power, and then put some people there. Don't be showing much
through electoral means, through the ballot.
Yes.
All right, thank you so much for your contribution. Appreciate them.
Don't
Appreciate it.
The government has been passed. I said that there will be a time that they will be blaming it on the judiciary, but it's not true. Let us do our own work very well. God bless Nigeria.
God bless you too. God let you go. Let's keep it as brief as possible so we can take as much as possible. There are loads, of course, coming in, and we need to take them. 0909-555-1039 and 0703-2277-338 numbers to call. You can also send in WhatsApp messages right here through the number 0703-2277-338. Would love to hear from you. We have this message on Facebook. We'll go right there and take this message. Well, you can also drop your message via the Facebook Live broadcast, or you would find this post right there on Facebook. You can drop your comments there, which is regarding the conversation today. Well, this is by RG Henry. He says, all eyes are now on Jesus Christ, the author and finisher of our faith. Days leading to the election was on the judiciary. Now he says his eyes on Jesus Christ. Well, let's go back to Fernandez, who's our guest, a legal practitioner, and we've been talking about this. Fernandez, we'll close this session when it's time with your thought on how this judgment could impact confidence in the electoral process in Nigeria. But let's take some more calls. Hello, good morning to you. Welcome to the show. What's your name?
Hello, good morning.
Good morning to you.
Good morning, Dr. Felix.
Yes, good morning.
Yeah, this is Joel calling from Lekki.
You're welcome.
Yes, I want to contribute one or two things in the
Please do so. Real quick, please do so.
Yeah, okay. Let me ask the INEC chairman, who is it by his own power? If you want to protest now, is it by election? How many years is INEC chairman will serve in office before he will step down for another person? Because you say you declare election in the night, this far, you go to court. Jonathan, these people are in court to defend their own right. Jonathan, so now you brought up, you said that there should be an evidence. So are you expecting almost how many polling units, or the whole eyewitness that was there for the whole polling unit that they read to come and testify? This man bring out some evidence in box and television and many things. Who they saw it? He said that there is no somebody that can stand it to our family. We are not, everybody is watching, we are white. But sometimes we need people to do what they need to do. Okay, yesterday they hand over everything to INEC, say that INEC have the power to transmit a result in whatsoever way. But they are the ones that come and promise Nigeria that there's going to be something that will transmit the result. Everything will be okay. So you will hold him according to his statement that he made. So he cannot make a statement now, tomorrow he dies back for the statement. Because there is no choice. Okay, what will make me next time to go and vote? Because I decided not to vote last time. But based on this device, this one will be different. That is why I say, okay, let me go and exercise my right. But what I the outcome, I don't even expect it. So the thing is just by selection. Let me just say it's by selection. It's what they like. That is what they pick there.
Thank you so much for your contribution, Joel. I appreciate it. Yes. Thank you so much. Thank you. We've got to move real quick, right? And Fernandez, their fundamentals, which we mentioned in the beginning, you've touched on the part where the petition, rather the tribunal ruled against the petitioners, especially Labour Party, as regards non-compliance with electoral guidelines and that the transmission of results. Well, one other thing which was ruled upon yesterday would be the 25% requirements of the total votes available in the Federal Capital Territory. Well, the ruling by the tribunal is that the Federal Capital Territory is like any other states. They don't have a special place, in the Federation or in the Constitution, and as such, a presidential candidate does not need to win 25% there to be declared a winner. Your thoughts, real quick, on this?
Okay, so the arguments are both ways. Actually, the arguments are both ways, and the reason is because the Constitution says 25% of 2/3 of the states of the Federation and the FCT. Now, a different provision of the Constitution had referred to the interpretation. I referred to the FCT as one of the states for the purpose of a particular state. So there are two schools of argument. The first school of argument is saying that if the Constitution had intended that FCT should be, if that particular provision had intended that FCT had become one of the states, it would simply have said 2/3 of the states of the Federation. In which case, FCT would ordinarily have be considered one of the states. So anyway, there are two arguments on this, and I think the court just took one, which is the one what seems reasonable to them in the circumstance, in the sense that they are looking at it from the perspective of 36 states. So the person has gotten everything everywhere, and then you're saying just one state that the person does not know what special status is that. But I think that it might have been the other way. But again, these things are 50-50, so I cannot completely say that this position is correct. I've had lawyers argue either way. I've had people argue that FCT must get the 25%. But I think this thing can go either way, and I think the Supreme Court is left for the Supreme Court to reach a decision. And once that decision is reached, they will clear the things out once and for all.
All right. There's also the issue of Fernandez. There's also the issue of forfeiture. $460,000 forfeiture. The courts, ruled that that fine, that 450,000 naira fine, did not translate to a criminal conviction. That was capable of warranting Tinubu's disqualification from contesting the presidential election. Perhaps you want to lend your voice to this decision from the PEPC.
So I realize that I'm pro-state in terms of the argument, but it's not because I'm pro-state. One has to just look at the laws. Again, as they are. But again, that forfeiture, it's possible that now again, we have different jurisprudence between Nigeria and in the US. So one has to look at that jurisprudence differently. Now, even assuming it was a criminal forfeiture, the reality is that the case was not against him. Nothing was proven against him. It was a third party that action was taken against. And then, of course, as a result of that, he had to forfeit that this thing. It was not him. He was not involved in that thing. In that case, it's more than 10 years ago. So because it's more than 10 years, there's the question as to, it's about 30 years ago. So is that something that you can rely on now? The law says 10 years. So it's 30 years ago. So is that something you can rely on now? But again, the thing is this criminal forfeiture, was he found liable for committing an offense? There's nothing in the documents that were given. People were hoping, and I have to say I'm one of those. We are hoping that, the court will do this. It's good to be hopeful, but the reality is from the documents we have seen, the documents did not say he had committed a crime, and on the basis of the crime which he committed, he forfeited this. He did not admit to doing any wrongdoing. Essentially, it was just money that belonged to a third party that was in his possession. And the court says that person, we have had issues with that person, and that person has done so. So that money that belongs to him when I was in his possession, when I was given to you on behalf of him, please forfeit that money. And that's that. So does that amount to, I mean, even between me and you, I mean, you give me money. So maybe for some reason, in a transaction, I'm with your money, and then the court convicts you or finds any other reason, and then as part of it, the court says, okay, that's your money that is in the other person's hand. You should forfeit it. Does that amount to criminal conviction? Not in my view.
Fernandez, we need to draw the curtains here, and thank you so much. Fernandez, Marcus-OBIENE is a legal practitioner and partner at TSEDAQAH. Okay, so it's pronounced TSEDAQAH attorneys.
Even though it's spelled TSEDAQAH.
Okay,
when
yeah.
you pronounce it, they know the F and the AH.
Yeah, I thought it came with 3 syllables, but apparently it's just 2. That's fine. Thank you so much for being on the program today. Appreciate your thoughts.
Thank you very much for having me.
Have a great post-judgment.
And I hope that I'm able to walk on the road after this, because throughout the call, it seemed like I was for...
No, you are very audible.
We can hear you clearly.
No, not all people are saying. I hope that people will allow me to walk on the street.
Including this person whose last call will take before you go. Just let's listen to this. Hello, good morning to you.
Yeah, good morning, sir.
Hi, good morning. What's your name? Where are you calling from? I'm sorry, I'm not sure we can take this. There's so much noise in the background. It feels like you're at a concert having fun. And, that noise is so much. Apologies about that. We've got to go, though, and go straight to Industry Hub. Because, I mean, the petition is just one part of a whole lot of things happening in the country, a whole lot of things, going on in the country. But let's go there right now. Industry Hub next on the Law FM Morning Show.
You're welcome to the Industry Hub of the Law FM Morning Show.